about were not true. But more importantly is this. When you say Regulation 90 says you are going to publish notices on how election officials and security officers are going to vote, IEBC needed to do a very simple thing. Namely, what did you publish to implement it? If you didn't publish anything to implement it, you are responsible for non-compliance. How do you treat non-compliance? You tell the Supreme Court. We could not be able to have non-compliance for reason A, B, C, D. Then the Supreme Court may decide to excuse you or not. But in the absence of that, non-compliance has been proven. What is the effect of this non-compliance? We have stated in our further affidavit, it's a numbers thing. If 700,000 people did not vote and you adjust it whichever way you want, you will still have a figure of 300,000. So that the long and short of it, my ladies and my lords, is this. Unless you excuse IEBC, and they did not ask you to excuse them, then you must find that the numbers in petition number 7 could have altered if those people had voted the results of the general election. And therefore, it is not permissible for anybody to be able to say, oh, it's a numbers thing. Petitioners brought no number. We brought numbers, and there was no response. We come to the issues of the issues of the procedure under Article 138. Under Article 138, that's one of the best done judgments that I've read. I've read it many times. It was written by artist Judge Jouko was there writing it. Catherine Mantoinoti was there. He was my pupil master. One of the best written judgments. I've read it many times. But yesterday, it somehow appeared I don't understand these things. So I read one more time yesterday night. And I thought, I think I understand what it says. So it was violated in 3 major ways, my lady. Number 1 is this, issues of the voter turnout. The issues of the voter turnout until yesterday, I thought is usually settled before the elections through the gazettement of a voters register. For these elections, it was done on the 21st of June 2022 through Gazette number 7290. But listening to my learned colleague, Mr. Somane, it would appear that fairly educated people like James Orengo, Firoz Noroji, Paul Mwangi can actually write petitions, and they were told in open court they did not understand what is all this about Article 190. And I also shuddered that if they didn't understand, probably I also did not. Issues number, the second failure, is this. In short, I'm saying the register cannot be mysterious. If the register is mysterious, the election is not simple, does not meet the requirement of Articles 81 and 86. Number 2, the stoppage of the public display. I didn't hear a straight answer to that. Now that there was no straight answer to the issues of the failure of results, and the 27 were not read, that goes straight to the root of the procedure under 138. If that was not done, my lords, there is no way in which you can be able to say the election was valid. For a simple reason, which is this, that when... I have 2 minutes.
2 minutes, okay.
Yes, I can read it. For the simple reason that we were dealing with under Article, for the conclusion, the whole point about Article 138 is that the procedure must be concluded. If it is disrupted, you have to hold that Article 138 was violated. The next issue is this, the third one. We talked about the issue of effective control. If you are convinced by what you have heard, and we have gone through this in the last 2-3 days, that IEBC lost effective control from 7:30 on the 15th to 6 p.m. when the results were read, there can be no basis for this court to say anyone was validly elected as president of Kenya. My learned colleague, Mr. Fred Ngatia, whom I respect a lot, said that William Ruto won these elections fair and square. That expression, fair and square, to my mind, comes from, as I understood, the famous judgment where Judge Madan was in the Githunguri case, where the basic point was this, that certain issues may happen that may make even a person who on the face of it could have been liable for criminal offenses not to be properly tried. And therefore they said it makes any conviction to be bad in law. You do not have a fair and square deal. Under Article 138, Raila Odinga, the other surrogate petitioners, they need a fair and square deal that their votes were not enough. Finally, my lady, the Chief Justice, Article 138 must not die in your hands. We are most obliged.
I think that brings us to the end of... Yes, that brings us to the end of Rejoinders. We are looking at Senior Counsel, Mr. Mwite, but we know very well your clients were respondents. It was only for the under representation that we allowed them to come just after the petitioners. They do not have a right of rejoinder.
Chief Justice, I am acutely aware of the time constraints within which this honorable court must adjudicate on this petition. And may I say that this honorable court is entitled, suo motu, to decide that the 14 days specified in Article 140 mean 14 working days. Yes, to exclude Saturday, Sunday, and public holidays. You can do that, suo motu. I am pleading, Chief Justice, I'm pleading on behalf of the 4 commissioners. I plead. They have had very, very little time in this court. I plead.
That is why I was looking at you with the questioning eye, because
yes,
there were some questions also which were asked, and they need to be responded to.
Yes, those are the ones. I'm just pleading.
Yes.
Allow my colleague Mansu Issa some 8 minutes, and Dr. Arroa some 3 minutes, and yours truly some 2 minutes only.
That is 15 minutes.
Because, yes, because...
To answer those questions.
Because, Chief Justice,
yes,
those questions directed at those 4 commissioners are very important. And
Thank
when
you.
others were answering questions,
yeah,
a lot of maligning, a lot of... Please give them that opportunity to have their case stated.
Okay.
They are the majority in that commission.
Thank you, Senior Counsel. I
thank
think we've heard your plea because we asked questions. So we'll give them 15 minutes to answer, not now. We want to take a break. And immediately we finish, there was an issue raised by Senior Counsel Gatia responding to some 2 Forms 34, and you asked for 5 minutes. And then we will give the parties 15 minutes not all the parties, the ones who are connected with the discovery and the scrutiny, 15 minutes in the afternoon to respond to the report.
I request, Madam Chief Justice, may I